All rise. Court of Appeals Division 1 is now in session.
Thank you. Good morning. Please be seated. This is the time set for argument in the matter of Gordon Acri versus State of Arizona et al. Two civil cases consolidated, 15-0349 and 15-0350. You've probably noticed that Judge Catani is not with us this morning. He has had a family emergency and could not be here. He will, however, be viewing the recording of these proceedings, and we've had audio recording of our arguments for years and years, but in the last couple of years we've added video recording capabilities. So this argument, the proceedings today, will be captured on a video. Judge Catani will review that before we make any sort of final decision in this matter. He's not the only one that can look at the video because it will be posted on YouTube. So any of you, counsel or any of the attendees here today, if you're interested, in about a week or two, you can go to YouTube and look for this argument and you will find it. We have read the briefs. We've been through the record. We're pretty familiar, I think, with the procedural and factual background to this matter. And so I'll just ask you to take that in consideration as you make your arguments here this morning. And each side will have 20 minutes within which to present their arguments to us. The appellant has the ability to reserve a portion of that for rebuttal. However, it's up to you to keep track of that, the time in that regard, counsel. With that, we'll proceed. As you approach the podium, please identify yourself and your client for the record. Thank you. Mr. Abney.
Thank you, Your Honor. May it please the Court, my name is David Abney. I'm here today with Dana Roberts, representing the appellant's plaintiffs in the case. There are a fair number of issues, but if I may, I submit to the Court that the big issue is duty. At the trial court, we were unable to persuade the trial judge that there was a duty, but under principles of law that go back, as far as my recent research shows, back to 1703 in England and definitely to 1809 in the United States, it has been a long-standing rule that if you voluntarily undertake to perform a task and you perform, then you also take upon yourself a duty to perform that task in a way that is not negligent. You need to perform it competently as you can, as well as you can, and not in a negligent way. And here the state undertook the task of protecting Yarnell and its people from the Yarnell Hill fire. That began right at the beginning and intensified as the fire progressed. It started on June 28 with a lightning strike. The state effectively did nothing at that point. Then June 29, the state took a number of measures to try to protect Yarnell, but it was on a hit-or-miss basis. Fire breaks, bulldozer lines, saw cuts, various other steps that the state affirmatively took to try to protect Yarnell.
How many others were also trying to protect Yarnell?
The state was in charge of the entire firefighting effort, Your Honor. And
were
that
other
involved
participants?
Were there other
Fire districts?
Oh, yes. There were fire departments from all across that area. Prescott Fire Department contributed, especially, most notably, the Granite Mountain Interagency Hotshots. But what the state does is mobilize resources. It has a cadre of professional leaders who are in charge of coordinating all the efforts for the firefighting personnel and equipment, tankers, and everything else.
But would you say that the relationship between the landowners is different, perhaps, as between a local firefighting district and the state generally in these circumstances, or are they identical?
I've never considered the issue. Off the cuff, I would think it would be similar. The difference being that in this particular case, the state's position is it had no duty at all to do anything other than deal with its own land, but it created a relationship because it affirmatively took measures to protect Yarnell.
Well,
but as far as
I expect we'll have that discussion with the state here shortly. But my question is, when you are a landowner and you pay taxes to a special taxing district, for example, for firefighting service, or there are municipal firefighting services, you rely on those services. Your insurers rely on those services. You have an expectation that they're going to be provided in a timely and competent manner. I'm wondering, though, how that reasoning that comes from the relationship locally extends to the state.
I'm not sure that it does. There is more the traces of a special relationship in the kind of arrangement that you're talking about. I'm not sure how far that affects the duty of the firefighters. I assume that you'd be able to argue, well, you had a duty to protect my home, I've been paying taxes for it, or if it was one of the rural districts where you actually have to be a special subscriber, that I subscribed, you'd actually probably have a claim in contract as well as in tort. You know, you violated the contract between us and I suffered damages as a result. But here the duty is different. It's the voluntary undertaking kind of duty, which the state acknowledged. And when we were at oral argument on the motion to dismiss, the state's attorney went into detail about how the state admitted that it had undertaken the protection of Yarnell, very specific about it. In the transcript, which is part of the record, the lawyer for the state said, I've gotten to know the forester really well, the state forester in charge of the forestry department. And that's the forester who just retired in December, Scott Hunt. He's been devastated by this event. He never failed to say to me, Brock, don't say we weren't trying to protect Yarnell. We were. And he knows that they were. That was their goal. They were trying to protect it by stopping the fire on the state trust land, which makes sense. And that's what they tried to do. It was a very sporadic sort of thing, and often self-contradictory efforts. The Granite Mountain Hotshots, for instance, were trying to set a fire break, and they actually got it going in the morning of June 30. And the air tactical controller called in 2 slurry drops and put it out. So you had all kinds of negligence going on here. That's pretty clear. You had incompetent firefighting effort. That's pretty clear. What derailed us at the trial court was the trial court's decision that there was no duty. But under principles of the common law, there was a duty. And that's really the essence and the heart of our case. And it goes so far back that it's actually something that Arizona accepted in 1925, the voluntary undertaking kind of duty, before the first restatement came out, before the second restatement, and before the third. What the restatements added on top of the notion that if you voluntarily undertake a task, that you're supposed to do it in a way that is not negligent, they added a little bit of icing, says, well, you need to rely. And we alleged that in the last series of our complaints, the Second Amendment complaint in one case, would be the Acre case, and the First Amended class action complaint in the Overmeyer case, we alleged that there was indeed reliance, that the people of Yarnell, there were a number of things they could have done if they had known that the state was just going to leave them in the lurch, and they didn't know. They saw 300 some odd firefighters and all kinds of equipment. They saw jets dropping slurry and fire retardant and water and planes. They saw this beehive of activity and reasonably relied on the state to protect their homes, to protect their lives.
Wasn't much of that activity, though, provided by others?
Oh, at the direction of the state, Your Honor. The state was, as we alleged, completely and totally in charge of the firefighting effort. They actually sent some assets away on the 29th in the belief that they weren't needed, which was, again, another negligent act. But the state was totally and completely in charge until July 1st, when thankfully the Bureau of Land Management stepped in, exercised its federal powers, and took over. And after that, there were no more disasters, no more firefighters cut off and killed, and things got under control very quickly, which is an interesting circumstance. But there's so many facts that we could have developed. I mean, I packed this. I wrote the complaint. Blame me if there's any problem with it. But I packed it with as many facts as we could find out at the time. Of course, you're under a very short timeline when you're dealing with the state. You've got a 1-year statute of limitations, and the investigations were not complete. There is so much more that we can add and delve into, and so much more that we will discover if we can get this case back at the trial court and get it moving forward. depositions to take, statements, documents to uncover, and build a very reliable timeline and move forward and establish just exactly how bad this was. But we allege in the complaint that it was pretty bad, what happened. And we also allege that the state voluntarily undertook this duty. Now, there's other issues in the case that I can discuss, but this is the heart. And if there's any questions about the duty, I would invite the court to.
Let's talk about the voluntariness for just a moment. When we talk about voluntariness, I'm struggling to see how it is that the state's actions here were truly voluntary. Did the state have the option to sit by and do nothing?
Yes, Your Honor. The state had the ability and the right to engage in firefighting activities to protect the state trust land, and it had the ability and the right, if it wanted to protect private property.
Doesn't it run contrary to the alternative arguments you make in terms of duty?
That's why it's an alternative argument, Your Honor. I believe, as a matter of public policy, that the state had a duty, but setting that aside for the moment as an alternative argument, which is not the strongest one, but still a valid argument, the big argument here and our main position is that there was a voluntary undertaking.
Would we want, as a matter of public policy, which is something we're required to take up under the Gibson decision, is it sound public policy to leave the state free to ignore crises like this?
It's miserable public policy, the worst kind I can imagine.
And so if that is not our public policy, if the state is not free to ignore crises, is it acting in a voluntary fashion when it follows the public policy of protecting the public?
If the court accepts that there is a public policy for the state to provide reasonable protection for people and property in the vicinity of a wildfire, that is a solid duty that the state should follow. If, however, this court decides there is not the
duty to provide the effort.
Yes.
It's no longer than a voluntary undertaking, is it?
If you look at it from the public policy sense, right. But then again, once you start getting into the public policy as a basis for duty, you still have the underlying question. The second question is, okay, so we have the duty. What are the steps needed to take care of what are the necessary steps to fulfill the duty?
But that's a question of fact, not of law.
That's the second question after duty.
I'm afraid we may be using duty in two different ways here. There may be a duty to undertake the effort to protect the public. That duty may not be the same as when we use duty in the tort context.
Well,
because again, your argument here hinges on the voluntariness of the conduct, not on the performance of an obligation imposed by public policy.
What matters most to me for this case, for getting this case back on track, is to identify the duty. Public policy is a possible basis for the duty, but then again, you get into difficulties on the edge. Well, we're talking about public policy. Well, is that just a general sort of aspirational kind of goal, or does it engender then the next step, which matters most for our case, which matters almost entirely for our case? Does that then create a tort duty? That's a difficult question. I would say that it would create a tort duty, but as I said before, it is our secondary argument. The primary argument is the voluntary undertaking, which definitively establishes that there is a tort duty of care.
Okay, and so let's go to your secondary argument. The tort duty that you're saying public policy creates is a duty to what? To manage and let me just give you a couple choices.
Yes, Your Honor.
Is it to manage the risk of a natural event on public land? Is it to manage other agencies in a responsible manner as the head of a firefighting effort? Which one of those duties are you arguing for?
Well, they're combined. The management of the other agencies is what the state undertakes when it fights any wildfire. It combines the resources that it has available, aerial, ground, local fire departments, districts. That's all part of one thing. But as far as managing, my response to that would be the duty that the state has, based on public policy, is to manage its fire suppression and containment efforts in such a way that, first of all, it protects people. Second of all, it protects man-made structures and property. And third of all, it protects its overall plan and fosters its overall plan for managing the wildfire area. That may be letting the fire burn in certain areas, because the fire hasn't burned there in decades. Let it burn, get rid of the rubbish and the undergrowth so that it'll be a safer environment for the future. It may be to direct the fire in certain directions. But number one is always protect people. Number two, protect their property. And number three, go forward with whatever overall plan you may have for rational wildland management. I think those would be the priorities for the state as far as fulfilling its duty. And it fell down here.
But the legislature's defined that to some extent, hasn't it, by the statute concerning the obligation of the state forester?
It has to some extent, but it's fairly vague, and I understand why it would be fairly vague, that you would want to give some discretion to the state forester as to exactly how to do these things. But I think no matter how vague the statute is or how precise, you've got to protect people first of all. And
how do you prevent then that duty from becoming, placing essentially an insurance obligation upon the state? Let's imagine that there's an even larger fire, and there have been, and that there's even greater loss of life because the resources available to the state are simply overwhelmed by the size of the calamity. Is the state still under a duty then to have amassed greater resources beforehand?
the state's problem here was not, just to be specific and then go
I know
back.
in this, I'm exploring the consequences of the rule you're advocating. I know in this case that was not the problem.
I believe that the
But
state's...
let's imagine a whole county's on fire.
Right. Which could happen. I wouldn't be surprised.
And the resources simply don't exist to cover that much land area. Is the state under a duty to have anticipated that and amassed essentially an army to do that?
The state's duty, I believe at all times, would be to protect in descending order persons' property and the environment. So
You've said that, but my question's different.
Well, I think it might be related, because then how you manage the resources at that point is you would have to conduct a kind of triage. You have to protect the people you can with the resources you have, protect the structures you can with the resources you have. If you can't protect the structures, of course, evacuate the people, which relates to number one as well. And then, last of all, if you can manage the fire in such a way that you get some good out of it, that you burn off areas that really need to be burned off, then let it burn in that area and devote your resources to steps 1 and 2 and leave, see if you can manage it better. The overall problem, and the problem in this specific case, is to manage the resources that you have in a way that is not negligent, which is what the state completely failed to do here. And it has done, and we'll explore this at the trial court when we get into the facts, that it has done better after this. But we are talking here about what happened with these people, their homes, their property, and quite frankly, it's a miracle that no civilians were killed in all of this, with the late evacuation and the fire moving as fast as it was toward the end. All of which we alleged was predictable. Every day they had the same wind and weather pattern. Every day in the morning it would blow away from Yarnell. Every afternoon the wind would blow back. You could set a clock by it. So why the state didn't take advantage of the weather conditions and do some burnouts in the morning and protect this community and its people and structures is just beyond belief. Your Honor, I think I'll rest on my pleadings, on my briefs for the other arguments.
Thank you, counsel.
Thank you.
May it please the Court. My name is Brock Heathcott, and this is Mike Parrish, and we're here representing the state of Arizona and its forestry division. I think, Judge Swan, you hit the nail on the head with your very first question in this case. And that was, is there a difference between the relationship between the state and these people and a municipal fire department and people that that live in their district? And the answer is clearly yes. The state enters into intergovernmental agreements with various districts that give the state the power to call on on fire districts to come to work for the state. And the fire districts always have the option of saying no and staying and because they have to put out fires in their own place if they don't have the capacity. Conversely, fire districts have the power to call on the state to come and help them in situations where they don't have the capacity. In this instance, there was a fire on state trust land, and it was in the state's jurisdiction, and the Forestry Division assumed responsibility of containing that fire.
Well, and that's the thing. Mr. Abney would characterize this effort not merely as the state chipping in, but the state assuming control.
The state did assume responsibility for containing the fire on state trust land because it was on state trust land. So it called in assets from other places.
And so when the state assumes control of those with whom local landowners have a more substantial relationship, doesn't it step into the shoes of that relationship?
You're talking about a contractual relationship, and the answer is no.
No, I'm not necessarily talking about a contractual relationship, but whatever the relationship is that is qualitatively different about one to a local fire service provider and the state generally. Once the state assumes control of those entities that people have a right to count on, doesn't it also assume an obligation to exercise that control reasonably? I
guess we're disagreeing is on what
I don't know that we're disagreeing. I'm just asking
what actual control there was. I'm sorry. The state has the power to call on people to their aid, but doesn't have the power to say, you must come work for us.
But the allegation is that essentially that there was a collection of people from various agencies working to stop this fire, and that the state supervised the effort and directed it. That's the allegation. I don't know what sort of factual disputes might arise from it, but that's the allegation we have to take at face value. So if the state decides to coordinate those efforts, doesn't it bear some responsibility for coordinating the efforts reasonably?
Sure.
And isn't that a duty?
Sure. The duty, when the
I
state...
want to make sure I'm not
Okay.
overreading that concession, because that sounds almost like you're saying the motion to dismiss should not have been granted because there is a duty.
No, I think I'm suspecting that counsel is contrasting what the situation was on state trust lands versus the way the situation turned out around the town of Yarnell.
That's correct, Judge. The state was working to contain a fire on state trust land, and even in the plaintiff's allegations, they recognize that throughout the first 2 days that this fire was raging, the state was attempting to contain fire on state trust land. It did not even acknowledge that Yarnell was in danger. And so if you talk about the elements of 323, that there has to be an undertaking, and that undertaking has to be to render services to these plaintiffs. There is no connection there.
Well, I understand that argument. I guess I'm approaching this from a slightly broader perspective, using Gibson as the guide here. If we agree, and I suspect the state would agree as well, that it would be poor public policy to announce a rule of law that the state can simply sit back and ignore potential tragedies such as this fire.
I would agree with that.
Okay, and I think we all would, and then the state, pursuant to its obligation to try to do something to help, does that. Should there be a public policy under Gibson that establishes a duty to do that reasonably, or does it enjoy some sort of immunity from liability simply because it's performing a task required of it by law?
Well, the way that we've always approached this case is twofold. One is whether or not there was any duty for the state to act outside of the confines of Restatement Section 323. And if there wasn't, did Section 323 create a duty by undertaking?
But is
So-
Section 323 the be-all and end-all? I mean, under Gibson, we have to ask, I think, sometimes bigger questions than what the restatement has supplied us with. I mean, the restatement is a useful guide, but it's a 51-year-old document now that isn't always hasn't always foreseen developments in the law since.
So if I understand you correctly, you're asking me what to kind of rehash the policy rationale for 323?
No, I'm asking you to leave 323 on the table for a
Okay.
moment and ask yourself under Gibson whether, and I think either of these two answers is possible, whether under Gibson public policy would say the state has a duty to aid. It performed that duty here. The question is whether it performed it reasonably, and by asking the question whether it performed it reasonably, we say, as a matter of public policy, there's a tort duty to do so. That would be answer one. Answer number two would be, we say, as a matter of public policy, that when natural events on state land occur that create hazards, it would be bad public policy, and therefore it is not the public policy to say that the state can be expected to bear liability for the consequences of a lightning strike on natural public land. One of those two, I think, is the upshot of this case. And so I'm looking for your rationales. I can guess which one you might choose, but I'm looking for your rationales for and against each.
Well, I'll talk about the latter one first because I think that's the easier question.
Sure.
There are very sound policy reasons why Arizona should stick with Restatement Section 363 about natural conditions. And at the very top of that list is that it spreads the risk. And in circumstances such as we have in Arizona, where there is a large quantity of wilderness, a circumstance that doesn't exist in a lot of other states, particularly east of the Mississippi, in order for the state to protect all of these interests that are bordering on wilderness that could potentially be subject to this kind of incident, it would be too difficult. It would be inappropriately difficult for the state to do that. But the risk can be spread to the people who choose to live in the urban wilderness interface. They have the ability to form fire districts to protect their homes. They have the ability to insure their homes. They certainly have the ability to fireproof their homes.
Well, what if they do form a fire district to protect their homes and the state comes in and takes control?
But what I'm suggesting is the state doesn't take control. The state has the authority to ask for the local assets to work under the state's supervision. But the intergovernmental agreements specifically state that those local assets have the power to refuse to work for the state if they're needed in their own district.
But in this situation, there was no intergovernmental or cooperative agreement in place concerning this particular piece of geography. So how does that change things?
The cooperative agreements would apply for the state to request assets from other locations to come assist in the containment on state trust land. And so in this instance, assets were brought in from Yavapai County and from Prescott and other places, also from outside of state, pursuant to those agreements.
So I guess I'm a little confused. It sounded to me like you're saying that the state did in fact come in and did take control over these other agencies in terms of coordinating an effort to fight the fire. And Mr. Abney has suggested that in at least a retrospective review, some of the decisions the state made relative to tactical decisions in fighting this fire were erroneous or negligent. And so the issue is why should the state not be held responsible for those decisions?
Well, where his case falls down is there is no special relationship between the state and these plaintiffs.
Unless they've assumed it.
And that's where 323 comes in. So there being no special relationship prior to the fire, certainly. And then when the fire started by lightning strike on state trust land, there was still no special relationship between the plaintiffs and the state. The state was undertaking to contain the fire on state trust land.
Well, what special relationship is required? I mean, they are citizens of the state, right?
Residents.
Within the zone of land that sought to be protected by the state's efforts. Isn't the question really whether public policy imposes any liability for failure to perform those actions reasonably, not whether there's a special relationship? I give you the example of road design. If the state designs a road that happens to include a 100-foot gap with a large drop, it will probably be liable for that without any special relationship between itself and those who happen to pass on that broken road.
Well, the distinction there would be that the people driving on the highway have a special relationship with the Department of Transportation, who is maintaining that highway. They're actually there. In this instance, there was no fire in Yarnell. Not until the very end of the last day was there fire in Yarnell. There was fire on state trust land.
All right. I guess maybe interpretation of Gibson is a subject that's been keeping lawyers busy for some time, but I have not heard of a case that requires both a special relationship and a public policy.
Right. I'm not suggesting that there is. I'm saying there is no special relationship, and that's why we've been analyzing this pursuant to 323 undertaking. And there are good reasons why there should be no duty in this case as well, duty to these plaintiffs. And those are the ones I've been describing, of spreading the risk and the difficulty in Arizona of there being so much wilderness. The character of wildland firefighting is far different from the character of municipal firefighting. Municipal firefighting, there's a fire at someone's business, and they have either they have or the city has a contract on their behalf for someone to come and put out that fire. Wildland firefighting, there is no control over that until the state goes and contains it and seizes control, and that containment may require the state to abandon certain assets, because containment is the goal. Now, certainly they would not intentionally abandon an entire city like Yarnell.
Have you looked at the law of any other state? I mean, Arizona faces a lot of fire danger. Other states face other dangers, floods, for example. Have you examined the concept of duty in those circumstances?
Well, Arizona faces floods as well.
It does, but generally not, at least in my experience, floods that threaten massive areas and the great loss of life the way this one did, this fire did.
What you're talking about with most flood situations are areas that have been massively developed, not areas that are wilderness. And in fact, the Beals case, in which the court adopted 363 on natural conditions of land, was a flood case in Arizona. Of course, in Arizona, fire and water are both intermittent. They're both natural conditions of the land.
So I guess what I'm hearing you say, Mr. Heathcote, is that as it relates to the state's management of the firefighting efforts on state trust land, that whether those decisions were appropriate or inappropriate or negligent or otherwise is not really the point. Even if those decisions ultimately placed Yarnell or some other community at risk.
Well, there's no allegation whatsoever that anything the state did placed these people at risk.
Well, I guess I'm wondering are you willing to concede that at any point the state would have had a duty towards these citizens?
If, for example, the state sent firefighters in to do some of the things that they say they didn't do, to clear out around the homes, and those actions were negligent in some way, then I would think, yes, that there could be some liability.
I think fairly read, the allegation is that the state managed firefighting resources in such a way that a fire naturally occurring on state trust land became more likely to cause harm to surrounding residents. Is that an unfair reading of the complaint?
I think that's an unfair reading of the complaint. I think
You don't think that's alleged?
No, it's not. I think we have, and the plaintiffs have agreed throughout that the one element of 323 that is not a factor is, did the state do anything to make the situation worse? If the state had not been there at all, it couldn't have possibly been better.
Okay. I'll ask Mr. Abney for his view on that when he returns. But if that's an agreed upon reading of the complaint, that would certainly help narrow the issues.
Any further questions?
No, thank you, counsel.
Thank you.
I'm in the unusual position for me of having 5 points I want to address. I'm in an unusual position for me of having 5 points I want to address, usually just one, but there's some very important things that were raised.
I want to start with the question I just asked.
Absolutely. If the state had not been there, then the people of Yarnell would have taken extensive measures to protect themselves. Emergency removal of rubbish and whatnot, trimming, soaking the ground with water, removing portable propane tanks, which turned out to be IUDs. They just exploded and spread the fire. Draining the large propane storage tanks, moving excess vehicles out of the way that would not catch fire and then explode, spreading the fire even further. And, of course, getting their prized and irreplaceable possessions and pets out of the way before they were consumed by the fire, having some sort of an orderly evacuation. If they had known that the state, all this flurry of activity by the state was simply just nonsense, Keystone Cops instead of actual acts to protect them, they would have cleared out of there, and some of them, I'm sure, would have stayed and fought to the end to protect their property. So there would have been a vast difference. As far as the defensibility, the state decided early in the morning of June 30th that Yarnell was not defensible, which got them into this self-predicting prophecy. Yarnell's not defensible, so we're not going to vigorously defend it. We don't vigorously defend it, and it turns out it's not defensible. It just goes round and round. But at oral argument,
Is there an inference to be drawn from the allegations of the complaint that the manner in which the state managed the firefighting effort, though, placed Yarnell more at risk from the fire?
It did, because of the reliance. The people.
I'm not talking about the human response so much as the actual progress of the fire.
Probably not in that limited sense, but in the broader sense of what happens to Yarnell's structures and people. Certainly what the state did placed them at greater risk because they were relying on it. Okay. And the state was just, it's like going to the county fair and playing whack-a-mole. That's what the state was doing, is trying to hit the fire where it wasn't, where it was, and it wasn't there. And so would keep doing that. That's what happened with the resources, instead of simply establishing a defensive line. As far as control at oral argument, my colleague stated when describing the control situation, here's what the state does. Firefighters from the U.S. Forest Service, other federal agencies, local districts, they all come in. Over 300 firefighters fought on this Yarnell fire. The State Forestry Division has less than 100 employees, but all of those people were fighting under the Forestry Division's direction and control. And they were the wildland firefighting team. All of them were fighting under the state's direction and control, which is what we alleged in the second amended complaint in ACRI, paragraphs 200 to 205, I believe it is. We alleged that the state was in control. And that's the problem. The state was in control, and the state didn't know what it was doing. As far as the restatement, the rule that Arizona adopted in 1925 was pre-restatement. It goes back a long way. The restatement picks it up in a slightly modified form in 1934, modifies it even more in 1965 to say that it applies to people and property and things. And then in 2012, they reiterate the same rule. So it's not an ancient rule. Well, it is and it isn't. It's an ancient rule, but it's also a very modern one. 4 years ago, the restatement reiterated the same rule. It is solid, good, contemporary law. I would direct the court's attention to the Anna Buguk case from Alaska, and I think I cited another case from Alaska, extensive wildlands. It has the same sort of problems, and it said that when its state, the equivalent of its state forestry division, undertakes a firefighting effort, it's got to do it in a non-negligent way. And I'm sure I've burned through my time. Thank you very much for your patience.
Thank you, counsel, for your briefs on this matter and the arguments you've presented here this morning. We will take that all into consideration and reach a decision and issue a written decision in due course. With that, we are adjourned. Thank you.